Hey guys and girls, welcome to this week's episode of the No BS With Birchy podcast. I'm your host, Nathan Birch. This is a show unraveling the truth to the facade of the 21st century. We're now exiting the matrix and waking up to motherfucking reality. Belinda,
Hi,
we have a special guest here today. Thanks for coming in. Very good, thank you. This is the first time you've been on the podcast.
Yes, it is, yeah.
I saw we were catching up. I was like, why haven't we done one beforehand? It's
exactly, so let's see how we go.
We've known each other for what, like 15 years or something now? Is it more than 15 years?
Possibly more, yeah.
Yeah. Crazy, eh? Crazy.
It has been a long time.
So, for those that don't know who Belinda is, maybe if you want to give everyone a bit of an understanding of your background, what you do and how we know each other. And
So, I'm Belinda from Zenith Legal. I'm one of the solicitors there. I've known Nathan since forever, since Stephen was doing his personal stuff, and now we're working together on settlements, and most of your buyers are using us. We provide conveyancing services. We can help you with estate planning and business structures. So that's a little bit about us.
I've definitely challenged you guys a lot over the years with like some of the stuff.
We like a challenge.
The stuff
that's always good.
And the cool thing is, I think it's about 2009 that we all met, and it's about that.
It's been a long
15
time.
years. Yeah. It's like crazy, and I guess today I wanted to get you on because I'm seeing a lot of weird stuff in the world, and we've seen Corona come in the last few years, and we won't go into any of that sort of stuff. But like people getting sick or unexpected deaths and stuff like that, and I think it's always important that people are prepared, right? Yep. People like the way I look at it is that. How many people, if you're watching this, is your car insured or not insured, right? If you're driving around a car that's not insured, I think there's maybe 1% of you, 2%, 5%. I reckon 95% of you would have a level of insurance on your car. But yet when you go and work 40 years of your life to, build up wealth for yourself, your spouse, and, your kids, and leave intergenerational wealth, and you forget to make sure that it's protected, right?
Exactly.
And everyone's got different things to lose in life. You've got your health, you've got your assets. I think the importance of working beyond the grave. Like people, I've seen and heard about stories where there's like tenants and they have no asset, right? But they've got like kids.
Property.
Yeah, kids or whatever. They're super fund and life insurance,
all the rest of it.
Where does it go? If you get incapacitated, who can look after you? Who can make those shots? And that's what I wanted to get you into.
Estate planning is crucial. It's not just having a will. Having a will is important because it determines what's going to happen to your assets once you die. With property investors, it's even more important given that you would have more than one property and you've got a plan and a vision. The way you create your plan, I think, for your future and the assets that you'd want to acquire, it is also important to take into account if anything was to happen to you, who would you want to be your financial person that would look after your finances. So in that aspect, you would have power of attorney drafted, and you'll have an attorney that will deal with your financials and how your money's spent, or a guardian. So essentially, if you lose physical capacity, someone to make lifestyle decisions on your behalf. So if you worked really hard for your money, it would be really important that you've got a person that you can trust, and that would make sure you live the way you would want to.
Yeah. I think a lot of people leave this too late in life. Like I've been having chats with my mother, right? And like my mum's 81 this year. And I'm like, you should really have, enduring power, like, having those around you to be able to make calls for you. It should stop you because you're not getting, we're not getting any younger. And they should, I'm going to be okay. I'm going to be okay. And it's like, my mum's stubborn.
We're all wired to think that we'll live forever.
Yeah.
Obviously, that's not the case.
Yeah.
So it's really important to get all your documents in order whilst you've got capacity. Once you've lost capacity, you can't nominate anyone, you can't draft a will, and it gets really complicated, and it's left to the authorities to make that decision on your behalf, and it may not be the best decision.
I've seen articles, I've heard horror stories about, a husband and wife, they could be have a house, a family house, and the I's not dotted and the T's not crossed, and then suddenly one of them die and the other one has to go and fight it out because they don't have the proper measures in place. And
depending on how the property is owned, if it's joint tenants or tenants in common, that would make a difference. But if you don't have a will, especially for blended families, it gets even messier, because in some states your spouse will get all your assets. So if you've got kids from a previous relationship, they miss out. In other states, the kids are also included, but then the spouse would only get a portion of your assets, and that may not be your
what you want. And each state's different too, eh?
Exactly. Yes.
So we've got some clients that have power of attorneys that they want us to be their power of attorney for different sort of transactions or whatever. And we can't just go, okay, we're going to operate and buy you a property in Perth and in Melbourne a day. And
so it's, in New South Wales, if you have a power of attorney, it needs to be registered if you want someone to sign contracts on your behalf. For example, in Victoria, that's not a requirement. So each state, it's slightly different. So you'll need to have that power of attorney registered where it needs to be registered. And
awesome. And I was thinking about this the other day because I see family situations that break down, like when some person passes or all this. I was thinking, like, I don't know if it's a thing, right? But it was a suggestion in my head, and I was like, everyone should be doing this if this is a thing. But like the family together, like, so the mum, the dad, the brother, the sister, everyone go get the will done at the same time, because then you all know, clear playing field, everyone's on the same page, it's all documented. Because I think it'd be really hard, like, and you see it where families, someone passes, then it becomes like everyone's fighting over money or something like that. And it's like, it wouldn't be the parents' wishes for that to occur. If they were here, they'd be really upset, and their kids are fighting and all that sort of stuff. So.
No, it is important, and it's important to draft your will the way you would want your assets to be transferred. So you can have a standard will where your executor will transfer your assets onto your beneficiaries, or your executor can also be a trustee. So by that way, you have a testamentary trust. So it's up to the executor and the trustee to decide whether they want to sell property or they can hold on to property and provide assets or income from the estate to the beneficiaries, and that's an extra level of protection. So if your kids are married and if they are going through a divorce, your assets will be protected, so that don't form part of their estate that is being split up.
I've seen crazy stories like, I hate him, but I'm going to wait for this to happen, right? And it's like, you just you don't want to be in a position where you've got you're stuck in a relationship with someone, or things are awkward,
So essentially, there's other ways you can protect your assets. If your will is properly drafted, you can have a discretionary trust or a few set up within your will, so that way your assets can remain as part of the trust, but then the beneficiaries decide who gets the income and how the income is distributed. So it could even go to minors that, from a tax point of view, that would be saving a lot on tax as well.
True. And you touched a good point there, Belinda, like with tax and all that. Say if someone's got $1 million house, it's paid outright, all that, and so there's, 2 kids, and it's going to go $500,000 towards each one. Would that be a taxable event? Is there an inheritance tax, or what happens there?
So there's no inheritance tax in Australia. If you transfer the property, if the property is transferred from the estate to the beneficiaries, there's no capital gains tax. However, if the beneficiary was then if they sell the property, then obviously taxes would be applicable. However, if that property was to remain as part of the trust, then until that property is sold, it's not subject to capital gains tax.
Okay. And random one, like, say, for instance, like capital gains tax came in like 1985. I'm really like, Belinda knows, I ask these randomest questions, right? It's like, where's he going with these?
So it depends on when the asset was purchased. If it's before the 20th of September 1985, the implications are slightly different.
Okay, cool. So, like, if there was, like, say it was a principal place of residence, say mum and dad, I don't know, something happened to them on the weekend, and then there's 2 kids or 10 kids, whatever. Let's say it's 2, just to keep it fun. $500,000 would be payable to each. The $1 million house paid out was a principal place of residence. If the 2 remaining people sell it, they get the $1 million. Would that mean that they have to pay? Because it was their principal place of residence, they'd have to pay.
So essentially, if they hold on to the property, they don't pay any tax. But if they decide to sell it, then tax would be applicable.
Crazy.
I mean, they should speak to the accountant, obviously, but
We're giving legal advice. No.
Capital gains in terms of the asset being transferred from the estate to the beneficiaries or to the executor. Capital gains tax is not payable, or stamp duty is not payable. If it's transferred from the estate to the executor, it's only minimal. And then if the executor is selling it, then obviously the taxes and implications would follow
from there.
Yeah.
Okay, cool. And so you said that there's the will, then there's the enduring power of attorney, and then enduring guardianship.
So they're the three main documents anyone should have. With the power of attorney, you can have a standard power of attorney. However, that ceases to exist if you lose mental capacity. So depending on the reason why you've got a power of attorney, if you're a busy individual that travels a lot and you need someone to take care of your finances, you may want to have standard power of attorney, and they've got specific instructions on when and how to sign and transfer funds on your behalf. However, if you've got an enduring power of attorney, that continues if you were to lose mental capacity. So you need to make sure that you've got someone that you trust that can manage your finances.
Yeah, cool.
And then enduring guardianship is making lifestyle decisions. So with the enduring guardianship, when it's drafted, you can provide advanced care plans. So you can answer a lot of questions. We can include that in your packet. So when the time comes, if you're in hospital and if important decisions need to be made, at least your guardian can be guided in terms of what your wishes were, instead of having to make that decision on your behalf. That can make it a lot easier.
And when there's emotion involved, and when people are scared or
and you
sad,
can have two. You can have two guardians acting jointly, or you can have an alternate in case if the original guardian is unable or unwilling to be your guardian. And if you don't have a guardian appointed, then the government may appoint a public guardian that may not make the right decisions for you. They may not put you in the right home or provide the right care, or it may be right in their eyes, but not what you wanted.
And I think, property investors looking at properties for sale, quite often you'll see like a public trustee sale, or and that's sort of when.
So that's if you don't have a power of attorney in place, and if you can't make financial decisions. If, for example, you need to be put in a home, the public guardian may decide that you need to go into a home and that needs to be financed, and then the administrator of your estate, obviously if you don't have power of attorney, may decide to take the easy way out and sell whichever property is worth the most. And maybe your intention would have been for your children to have that property, but obviously that decision is no longer made by you, but it's made by someone else.
Yeah, cool. And I think like the earlier you can do it, the more decision, like more clarity you can have like in your life, and go, that's what. It's
like a holistic approach. So you just need to kind of sit down and think, okay, I've got this plan, I've got these assets now. I wish I'll have an extra 5-10 properties, or whatever the intention may be. So you create a plan and vision for life in terms of what you want to achieve if you have the capacity. However, at the same time, it is important to look at it as, if something was to happen, for you to have that plan in place and for it to be documented. So unless it's properly documented, then it's not in effect. And maybe if your close people know your wishes, and then they may try and apply to be your guardian and to be a financial person. However, it is up to the government bodies to decide if they're fit for the purpose. So they may not be appointed only because they're your spouse or because they're your children.
Yeah. And I think, like, I just think back, like, seeing, like, things can happen to us at any time. Instance. Yeah.
Exactly.
Go out on the road, go out on the
anything,
young sports, whatever, things happen. So it's like, I think it's really important.
It's just really important to have them in place. Obviously, you can always review them, or if you want to keep them more basic and for them to remain in play for much longer, that can be done as well. It's just about having that plan and having it drafted in a way that you are protected at any given time, and keeping your close people informed. For example, you may have a few children, so you may have 3 kids, but maybe only one of them is responsible that can make good decisions on your behalf. And if you don't have them appointed, then it creates family issues. And that
takes me on to another question, Belinda, as well. Like, depending on like the time, like you might do a will today, but in 3 years' time or 5 years' time, when would you update it? Like,
So it really depends if you are leaving specific assets to specific beneficiaries. If you are leaving all your assets, for example, to your spouse and then on to your kids, then no matter what assets you acquire, what you sell or what you buy, the will still be valid. However, if there's specific assets that are left to specific people, if you were to sell something, then you should update your will because that asset is no longer available. Obviously, if you get married and your will prior to marriage is void, it's slightly different if you get separated or divorced. Then your spouse, anything that was allocated to the spouse in the will, that lapses and that's void. But the remaining terms of the will remain.
Okay, interesting. And like some people might imagine, I'm sure that someone out there in the world that's like, I hate my ex, right? And they've split up and they've had some will and someone's carked it. And then the next minute, it's like, oh, that person, like, if someone's divorced someone.
It's based on the wording. So if in the will you specifically state to my wife so-and-so or to my de facto partner, if it was to be taken to court, it may be viewed that the intention of that person was for the wife to acquire the asset. So if that person is no longer the wife, automatically would indicate that the wishes are for that asset no longer to go to that person, rather to the next. Or if that person was only named by name, then no matter if they're the wife or not, the asset would potentially go straight to them.
I was just thinking, if someone got divorced when they were 30, got remarried when they're 40, they're 60 now, 30 years ago, some chick that's my wife, that they go, oh, see you later, right? And then they can't get now, and it's like, hey, I don't know.
They could contest a will, but there's a lot of steps that need to be followed, and that's why if you are leaving someone out of your will, we normally recommend to clients to write an explanation as to the reason why. So if anything was to happen, it goes in front of a judge. He can take that into consideration because it's your words, it's your explanation and reasoning. If you've lost contact with someone and you haven't spoken to them in 10 years, at least they'll know that there shouldn't have been that expectation that they'll acquire any assets from you because there has been no relationship. Or if you've given, one kid a lot more money whilst you were alive, then you can provide that as an explanation. And if they get the same assets as your remaining children, then you're disadvantaging the other two kids, for example, that haven't gotten the same assets.
Got it. And do people ever like film like a little video? Like, I always think that would be like.
I'm not sure if that would be admissible, but
wouldn't be?
Never know.
Okay.
I mean, could be.
I'm just curious, asking.
We're all based on paper, but I mean, if a client comes in and films a video, it's possible.
Yeah. Okay. Interesting. And do you have any sort of examples of like where things have gone good and where things have gone bad in a situation which? That you can share subject to.
We had a client that had an existing will. Her assets were being split equally between three of her kids. The will was drafted over 25 years ago. She instructed us to create a new will, leaving two of her daughters out because she had lost any contact with them. She hadn't spoken to them in 20 years. The son and his daughter-in-law were looking after her. So she essentially was leaving all her assets to her son, and if not to son, to her daughter-in-law. We took the instructions before the will was finalised. The client passed away. So it was in front of a court to decide. I'm not sure of the outcome, but her instructions, although the will was not finalised, those instructions were taken into account. And the elaborate explanation and the reasoning behind why her daughters were left out of her will were taken into account. So hopefully her wishes were
respected. And wow, it's there's so many elements to it when it comes to a law case and a legal case. It's at
the end of the day, it's up to a judge to decide, but the more supporting evidence and documents you've got, the better. Awesome. Cool. And is there any sort of tips or anything you could share? Look, financial agreement's always good. You can always do a financial agreement before you enter a relationship, during or after. They could be helpful because they can kind of support your will as well.
Okay. Do you guys do prenups, or do you just do like?
We can draft them. Each party will have to get the individual legal advice, obviously. But as long as everyone is on board and they're in agreement, we can help out.
There we go. Insurance is always out there, but people relatively don't.
Exactly, and it is really important to note that your super fund, you need to make sure you nominate your beneficiaries with the super fund direct if you are with a super fund provider. If you've got self-managed super fund, then that goes based on the trustee, but also life insurance. So ensure that you nominate your beneficiaries in your life insurance policies, because that don't form part of the will as such. They're separate to the will.
I have heard of that beforehand where children are in the mix and separated. Like I've heard of, without going into any details, I've heard of situations where like a partner's passed as a kid, it goes not to the partner, to the kid, and the kid's not of age and all that sort of stuff. So if they're dependent, any life insurance payout, or to the spouse, I believe tax is not payable, but once the kids are adults, any income from life insurance policies may be subject to taxes. So that's another point to take into account. Yeah, cool. And how easy is it to get a will? And
the process is fairly easy. So we give you an instruction sheet, you provide your instructions, we confirm your instructions, and it's only one appointment to come in and sign it. It is very important to sign it in person. We can provide instructions to sign it yourself and have it witnessed. However, the witnessing process needs to be followed for the will to be established as valid, because once probate comes into play, for the Supreme Court to grant probate, the will has to be valid.
True. And I think that's what a lot of people don't look at. They're like, I want something done now, it should be done like this. And it's like, if you don't have every I dotted, T's crossed, then it could.
Exactly. And the wording, little words can make a big difference.
Yeah. Awesome. And I think I strongly suggest, I think everybody should have those 3 documents, because at the end of the day, it's not much, right? Like, and everybody's position, I guess, is different, and the costing is different. But it's like car insurance for the year. It's a car premium. It's like, it's not the house insurance.
Definitely.
It's not tens of thousands.
You do it once, so it's not something that you need to do it all the time, unless you
change things,
your situation changes. But essentially, yes, it's really important to have it. A simple trip to the bank to get some money out if you're unable to transfer funds, that won't be able to happen until they appoint a financial advisor.
Cool. Thanks, Belinda. If anyone wants to get in contact with Belinda and the team at Zenith Legal, click on the link below. There's a little banner here with information on how you can contact with Belinda and the team. What's your best email? Is there an email where people can reach out?
So belinda@zenithlegal.com.au.
Awesome. Thanks, Belinda. Appreciate that. And thank you for
Thanks for having me.
Pleasure. And thanks for all the work that you and the team put in place for me personally, because I know I'm a pain in the ass, right? I'll just say it publicly, right?
Pleasure.
And you guys are always there, and like, I never have to worry about any I dotted or T crossed, because you've got it covered in every.
We try our best, especially with all the ideas that you've got. Sometimes it's challenging, but we do try our best.
Awesome. Thanks, Belinda. I appreciate that. And if you guys like this, share it, give us a thumbs up, and make sure to subscribe. We're out every Thursday on Google Play, Apple Play, Spotify, and YouTube. We'll catch up soon. Have a great week. Bye for now. Like Bilal said, man, we're stuck in the matrix. This my advice, don't care if you take it. The dollar back to die, soon to be hyperinflated.